Have some gremlins with the YouTube. We are online. Okay. Good morning. The Maryland Public Service Commission is on the record in case number 9681. It's the matter of the application of Delmarva Power and Light Company for an electric multi-year rate plan. We will begin today by taking appearances, starting with staff.
Good morning, Mr. Chairman, members of the commission. Annette Garofalo, appearing on behalf of the commission staff, together with Peter Wilson, James Greger, and Hunter Davis, who's to my left.
Thank you, Ms. Garofalo. We'll next turn to Office of People's Counsel.
Good morning, Mr. Chairman and Commissioners. Nikki Wiggins on behalf of Office of People's Counsel. Also entering appearances for David Lapp, People's Counsel, William Field, Deputy People's Counsel, Jolie Bell, Deputy People's Counsel, Nicole Zeichner, Assistant People's Counsel, and Michael Sammartino, Assistant People's Counsel.
Thank you, Ms. Wiggins. It appears that the entire office.
That's the whole crew.
We will turn to the applicant, Delmarva Power and Light Company.
Good morning, Chairman, Commissioners. Kim Curry representing Delmarva Power. I'd also like to enter the appearances of Matthew Seegers, Douglas Mikeel, and to my left, Taylor Decker.
Thank you, Ms. Carty. It's been several years since you've appeared before the commission.
It's been about 4 years, yes.
Welcome back. On June 9th, we received a petition to intervene from Walmart Incorporated. Is a representative from Walmart here? Would you like to make an appearance from the podium?
Yes, good morning, Mr. Chairman, Commissioners. My name is Barry Naum. I'm here with my colleague Stephen Lee from the law firm of Spellman, Thomas & Battle. We represent Walmart. I would hesitate to make a formal appearance. I would note for the record that our motions for temporary admission have not been filed yet. Those will be forthcoming, but we are at your discretion here to answer any questions that you have for Walmart.
Okay, please let us know when those are approved by the court. In the meantime, I will ask the parties if there's any objection to granting the petition for Walmart.
Staff has no objection, Your Honor.
Okay, seeing no objections, the motion is granted subject to approval by the circuit court.
Thank you, Your Honor.
Thank you. Are there any other parties that have not filed a motion to intervene that would wish to make an appearance? Seeing none. Ms. Curry, does the utility have any exhibits to be admitted?
No exhibits today.
Okay. You will be publishing notice and
We will be filing our certificate of publication today
with the commission today.
with the commission today, yes.
But you don't have anything to share with us in the hearing room today.
I do not.
I wanted to confirm that. We have a situation with respect to the proposed schedule over the course of the rate application. And it's rather unfortunate that the parties at this table were not able to come to consensus with respect to one schedule. And that puts the onus on this commission to determine the schedule in that case. Staff schedule and the company schedule are relatively close in alignment. It seems like a few dates here and there. OPC schedule, however, was rather surprising, assuming that we would have a 300-day clock based on a statute that is not currently in effect. Ms. Wiggins, let me ask you, how could the commission possibly support your schedule?
Thank you, Your Honor. It's known House Bill 228 was meant to swiftly address a clear issue that arose in adjudication of the multi-year rate plans that have come forward at this point. The issue is that it's not possible to do a multi-year rate plan within the time frame that's laid out for a traditional rate plan. It was introduced, passed by both houses, and fully approved by the governor before the company filed its case in the instant case here. And the commission expressed its support for the bill in January, noting that the 90 days would be essential for multi-year rate cases. The commission will have authority on October 1st, 2022 to extend the suspension of Delmarva's rates by an additional 90 days. It benefits all parties, including the commission, to allow for that schedule when we are doing this procedural schedule now. It's been the commission's practice when a statute change occurs while a case is pending before it to apply that statute. Most recently in case 9669, CPCN application by Potomac Edison. That application was made in August of 2021. In October of 2021, House Bill 298 came into effect, which required additional factors to be considered in CPCN applications around climate change. And the commission promptly sent out notice that the new factors would apply to all pending cases. And that's consistent with what Maryland case law says, particularly in this case where the change in the law will be procedural, that it can apply to and should apply to pending cases. The Court of Appeals has stated that procedural statutes are an exception to general considerations involving retroactive rate making. And so as long as the statute doesn't affect any substantive right by a party, it should be applied unless there's a contrary intention listed in the legislation. In this case, there is no substantive right. It's strictly a procedural issue in that we're going to have an extra 90 days to do the multi-year rate plan. In that case, we should contemplate that those 90 days will be added when the commission has authority to do so in October, and we should build them into the procedural schedule up front. That's OPC's position.
Thank you, Ms. Wiggins. I testified on behalf of the commission in support of the legislation for the reasons that you articulated. You are correct. The governor did sign that bill into law to take effect October 1st. You stated that the additional time would likely benefit all parties. I suspect that the council to your right with Delmarva would disagree with you there. You noted a few cases where the commission included additional factors along the way, but a procedural schedule that we need to set today that includes forecasted data that the company was not expecting when they filed this application back in May could potentially throw their forecast off by 90 days on the end of this proceeding. I see no reasonable way that the commission could implement a 300-day statutory clock when that law is not effective as of either today or the date that utility made its application with the commission. So we will set aside OPC's procedural schedule and look at the two other schedules, which I noted earlier are very close. I was actually struggling to see the difference. It was a few days. Could either Ms. Garofalo or Ms. Curry explain why the dates were off by a day or two? Why you couldn't?
We did actually not discuss staff schedule, but this is the schedule that was circulated to my witnesses. And the reason for the differences is that although direct testimony is due a couple of days earlier than by Ms. Curry's schedule, the reason for that is to allow the amount of time that's needed for rebuttal testimony, which the staff schedule allows a little more time for that. And that's often, one can never know in advance, but that's often a very important round of testimony for the parties who are not the company, because they cannot do live rejoinder, and the issues have have coalesced at that point. And so we would ask that these two changes be accepted, along with a third change, which is that discovery responses after the 19th, which is the date for rebuttal testimony, be turned around in 3 business days rather than 5. The reason for that is the same reason as for giving a little more time to rebuttal. The company and staff did discuss that particular change in the schedule. There are several cases. I just looked at recent cases. And while the MRPs did not do a shorter turnaround time, case number 9671, 9664, both had 3-day turnarounds for rebuttal, and case 9670 used a 4-day turnaround for that at that stage. It's important that the witnesses have an opportunity to do a second round of discovery, because sometimes we might ask a question, the answer that comes back is a surprise, and it requires additional questions. Also, sometimes the answer isn't, we feel, not complete. I'm not saying that it's meant to be incomplete, but so that's the reason for asking for the shorter turnaround.
Thank you. A very, very thorough reason, Ms. Garofalo. Ms. Curry, did you have anything to add?
Yes, we object to staff's schedule. There are a couple of other nuances. One being the rebuttal testimony you could see is only limited to staff, OPC, and the interveners. We would like to be able to file rebuttal. We're glad that staff agreed to, or does not object to allowing us to do live rejoinder. We would like to do that. And the responses to discovery requests, Ms. Garofalo, as she mentioned, the one that we put forward, the one that Delmarva put forward, is consistent with the BGE case as well as the PEPCO MYP case, where both cases got 5 business days to turn around data requests. We have the burden, we have the burden of having to produce this data. The additional time can help us make sure that we get good, clean data to the parties. So we would object to the 3-day turnaround and ask that our 5-day turnaround be accepted.
The 5-day turnarounds with respect to the discovery request served after September 15th.
Yes, after rebuttal testimony. The staff has not articulated a different or a reason why Delmarva should be treated differently than PEPCO and BGE.
Ms. Curry, you're asking for 5 days. Ms. Garofalo, you're asking for 3.
Yes.
Can you answer Ms. Curry's question as why there should be a distinction?
Well, though they just happen to be different cases, and I suppose it is consistent if you use 5 days, but we would still ask for the 3 days in order to have a second time for discovery.
I suspect I won't make anybody happy today, so we'll go to 4 business days. Since the parties could not reach consensus on state. Also, since we don't have consensus on the schedules, and there appears to be disputes over rebuttal testimony.
Could I address that? So the company has the opportunity for live rejoinder. No other party has that. And the company is asking to rebut its own, they're the main party that's going to be filing rebuttal testimony. It really doesn't, to me, make good sense to give them both those opportunities.
And I would respond by saying in both the PEPCO and BGE MIP, the applicant was given rebuttal, the ability to file rebuttal.
This is disappointing on so many levels. This is my first pre-hearing scheduling conference in 4 years that has taken probably more than 10 minutes. The fact that the parties, the 3 of you at the table, and welcome to the table, Mr. Now, couldn't agree on something as simple as a schedule doesn't bode well, particularly disputes over 3 or 5 business days. What we're going to do is remove sir rebuttal testimony entirely. It's going to be stricken. There's going to be no sir rebuttal testimony for anybody. This is going to be the schedule. Direct testimony will be due Friday, August 19th. Rebuttal testimony will be due Monday, September 19th. The comparison chart will be filed on the first day of the trial, September 27th. The trial will last 4 days, from Tuesday, September 27th through Friday, September 30th. Initial briefs will now be due much earlier, October 19th. Reply briefs will be due November 2nd. And the order will be issued by the commission no later than Thursday, December 15th.
Your Honor, may I push back on the elimination of sir rebuttal?
It's kind of late, Ms. Curry, but you may.
This chart that staff presented, we did not see till yesterday. So it wasn't like we discussed this and we couldn't come to an agreement. We did not see the fact that they were taking out sir rebuttal until yesterday. So it wasn't part of the original discussion.
Well, let me stop you, Ms. Curry. Staff was not taking out sir rebuttal.
It's taking it out for us. So they're taking it out for, they say on their chart that staff, OPC, and interveners only apply. So they're taking it out and not allowing us to do it.
I see that.
Inconvenient or inconsistent with prior MIPs. So again, staff is treating us differently, treating Delmarva Power differently than other MIPs that were have been before you and have not provided a reason for the differential treatment. But we did not discuss this, so it wasn't like we discussed it and couldn't come to an agreement.
Did I not resolve the problem by striking sir rebuttal testimony in its entirety?
Well, we would like the opportunity. Again, we have the burden, so it's an opportunity again for us to make our case. So
you'll have the opportunity for live rejoinder of the rebuttal testimony at trial. Do other parties have anything to say with respect to this new schedule? And I recognize that this is different and this is a break. I don't believe there's any due process concerns here. Parties will have an opportunity to question witnesses at trial. Okay.
Your Honor,
Ms. Wiggins.
I'm sorry. Just to clarify, we'd like some opportunity, or we'll need some opportunity to respond to company's rebuttal. Is that going to take place at the hearing?
Yes.
Thank you.
Oh, well, just to be clear, I think you said through cross-examination, but are you saying through rejoinder? No.
Through rejoinder, correct.
Oh, thank you.
And this will be memorialized by the executive secretary. He'll issue an order sometime in the very near future. So we'll turn to discovery timelines. We had a dispute there based on our new schedule, more condensed. And again, this schedule is as a result of the parties not being able to reach consensus on their own. The discovery timeline will be as follows. Responses to discovery requests served through August 19th, 2022 are due within 10 business days, and objections to discovery requests must be served within 3 business days of service. Responses to discovery requests served after August 19th and through September 19th, 2022 are due within 7 business days of service, and any objections to discovery requests must be served within 2 business days of service. Response to discovery requests served on and after September 20th, 2022 are due within 4 business days of service or best efforts, and any objections to discovery requests must be served within 2 business days of service. Those are the discovery timelines. I did appreciate Delmarva Power's additional rules, and I'll incorporate them here. As general rules, the parties should consult with each other and attempt in good faith to resolve all disputes prior to making an objection, and again, prior to filing a motion seeking relief from the commission. In the event that the parties are unable to resolve a dispute, the aggrieved party may file a motion for relief within 3 business days from service of the written objection. The opponent shall respond to the motion within 2 business days of service of the motion. The motion and response shall be in letter format and shall be limited in length to 2 pages. The motion must specify the dates and times of all consultations for the purpose of resolving the dispute. Party shall contact the executive secretary via email to schedule a hearing if necessary, and provide the executive secretary an electronic copy of the motion and response. And of course, all testimony and discovery shall be electronically served on the parties unless a different format is mutually agreed to. Any questions on discovery rules? Seeing none. Pursuant to Order 90240 that we issued on May 20th, discovery commenced for Commission staff, Office of People's Counsel, and Delmarva Power. Discovery will commence immediately for Walmart in this matter. Public hearings, we will have 2 evening public comment hearings. We will conduct them virtually using the WebEx platform. I would ask that the parties work with Mr. Johnston to schedule the dates and times of those hearings. Before we conclude today's scheduling conference, do the parties have any additional questions of the bench?
Staff has nothing here, Honor.
No.
Thank you.